Hi, okay, welcome to Svanosio and McNamara. All right, so let's go through this case. So in this case, McNamara sold Svanosio a hotel, okay, a pub, the Bull's Head Hotel to be exact. In terms of the price, it was sold for £5,000. The majority of the price was made up of the goodwill and the hotel license, which was valued at £4,200. However, there was component of the sale price for the freehold land on which the pub was situated. After the conveyance was completed, Svanosio found out that the hotel was actually located partly on Crown land, okay, which was approximately a third of the hotel was located on Crown land. And because it was Crown land, it meant that Svanosio wasn't able to bring a claim for adverse possession. So both parties had operated under the common mistake that the hotel was fully situated on the freehold land that was sold for £800. Okay. Now, interestingly, in this case, the contract itself actually provided a clause on mistake as to title, which suggested that if the mistake as to title was found within a certain time period, compensation was to be paid. However, here, that clause, that time period had passed because this was actually after the conveyance had been completed, after title was fully held by Svanosio. It was at that time that he found out about the mistake that had been made as to where the land, where the hotel was situated, and the fact that it was partly on, or a third of it was on Crown land. So the key issue in this case, so here Svanosio wanted to show that the contract was void for common mistake. So he was seeking that common law remedy, okay? But as we'll see in a moment when we run through the reading guide questions, the objective view of contract applied. And here you had 100% completed, executed contract. The title had already passed. Okay? And yeah, as we'll come to in a bit more detail in a sec, the contract was found to be not void for common mistake. And in the process of coming to that conclusion, the judges actually gave us some guidance around when equity will intervene in sale of land contracts when the conveyance has already been completed. And the answer is very rarely. Okay. All right. So in terms of the case reading guide questions, what was the plaintiff seeking? Okay. He wanted a declaration that the contract and conveyance were void. He wanted that contract and conveyance set aside, even though he now held good title in the property. And he wanted the repayment of the money that he'd paid under the contract, which was the £5,000. Okay, so had the land been conveyed? The answer was yes, it had. Okay, it was a bit late for Svanosio. And when will the court grant rescission of the conveyance? So here, the judges stated, Dixon and Fulliger gave the test at 126, and they stated that conveyance, that the only times that a court will grant rescission of a conveyance, rescission being, being able to set it aside, which is when there has been fraud or misrepresentation or a condition that can be found to be expressed or implied in the contract. Okay, and what they mean there is that condition precedent. Okay. In terms of the meaning of fraud, fraud in this context can include fraudulent misrepresentation. Okay, and if you remember back to the Taylor and Johnson case, the court gave fraud a very broad, equitable interpretation to include unconscionable dealing. Okay, so Chief Justice Dixon and Justice Fulliger note that contracts for the sale of land present peculiar features of their own. Okay, so here they're talking about caveat emptor, okay, the idea let buyer beware. And the idea being when you buy land, it's up to the purchaser to investigate the validity of the title, okay? And with that caveat emptor doctrine, let the buyer beware, the risk is allocated to the purchaser, which in this case was Svanosio. Svanosio could have actually discovered the defect by having made a proper survey of the property, which he didn't do, okay? So he only made there was only a quick cursory inspection as to title, but there was no survey actually conducted. And if Svanosio had discovered the defect before conveyance, the mistake would likely have been enough in equity to then resist specific performance, okay, because he could have argued that he had a right to rescission, because at that time restitutio integrum was still possible. It was still possible to go back to the way things were before the conveyance had taken place. We'll come back to that, that relevance of specific performance in a moment in one of the next questions on the next slide. So in terms of the fourth question then, so can you formulate the decision in this case in terms of the doctrine enunciated in Taylor and Johnson? Okay, so you want to be having a look at page 432 of the judgment, and the quote on that page that's relevant states, "A party who entered into a written contract under a serious mistake about its contents will be entitled in equity to an order rescinding the contract if the other party is aware that circumstances exist which indicate that mistake and deliberately set out to ensure that the first party does not become aware of that mistake." So that quote there suggests that if McNamara had found out about the defect and was aware that Svanosio was mistaken about the placement of the hotel and intentionally made sure that Svanosio didn't find out, then under that principle in Taylor and Johnson, Svanosio would have been entitled to rescind the contract. Okay, so it's essentially just restating that principle in Taylor and Johnson, that the mistake itself is not enough, but if there's some error, some aspect of unconscionability or that, you know, that dodgy, sharp dealing, in that instance, rescission will potentially be available. Now, in terms of the fifth question, in what circumstances do Chief Justice Dixon and Fulliger contemplate that equity might provide relief for common mistake? Okay, so we'll just run with that judgment first. So you're wanting to have a look at pages around 196 and 198 here for the answer to this question. So the judges state that equity may provide relief for common mistake where the mistake may give grounds for equity to refuse specific performance, okay? In one of those Taylor and Johnson type instances where the other party actually knew of the mistake and then did something to engender that belief in the other party or their continued belief in that. And they also state another alternative, and that's where it would be inequitable that a party should be held to a contract. Equity may set aside the contract where there's been fraud or misrepresentation or total or practically total failure of consideration. Okay, and that's at 198. Now, in the McTiernan, Williams and Webb judgment, their comments you can see around page 207 and 208, and they state here that the contract cannot be set aside on the ground that the purchaser was induced to enter it by innocent misrepresentation. So that's that same idea in Taylor that, you know, an innocent, if the other party is innocent, that's not enough of itself, or innocently concealed some defective title. They said actual fraud must be proved. They also note the exceptional case when there might be total failure of consideration as being another ground when equity might intervene. And the example they actually give there is if the purchaser purchases a property that they actually already own. Now, if fraud is taken to mean unconscionable in its wider sense, then it seems possible under both judgments for equity to potentially intervene, which suggests that consistency with the approach in Taylor. However, one thing you should note, if you've got a question like this and a problem question, is that McTiernan, Williams and Webb specifically exclude equity from contracts for the sale of land. So they say technically it's possible in a case of common mistake for, equity to intervene. However, not in these types of cases. Okay, so keep that in your notes. All right. Okay, so that's Svanosio and McNamara.